The Illinois Supreme Court will hear several cases this month about the state's pretrial release law.
WAND's Mike Militich has learned the top court could decide whether people can use good conduct credits, as they're called, to reduce pretrial jail sanctions.
Geoffrey Seymore has asked the state's top court whether good conduct credit could be used to cut down on jail time he received after violating pretrial release conditions. Seymore is facing several drug charges related to meth, but a circuit court judge released him on electronic home monitoring. Yet court records show Seymore violated the conditions of his release the very next day by leaving his home, leading the state to ask for pretrial jail sanctions. The circuit court judge imposed a 30-day jail sanction and noted he would not be able to use any good conduct credits to shorten the amount of time behind bars before trial. But an appellate court judge argued the circuit court was wrong and Seymore should have been able to use those credits.
Because the consequences of a pretrial jail sanction happen to overlap, somebody might serve a sanction in jail, somebody might serve a sentence in jail, does not mean that those categories are completely synonymous. They are not simply interchangeable.
Seymour's attorney says good conduct credit should apply in his case, as the Illinois County Jail Good Behavior Law does not exempt pretrial sanctions. He argues sanctions are considered the same as a sentence under common state law and should qualify for good time credits.
The state's trying to create new law here. They're trying to add a seventh exception to the Behavior Act that does not exist. The Pretrial Fairness Act, while it mentions sanctions, it does not say sanction is not a sentence. This functions like a sentence.
Reporting in Springfield, Mike Militich, WAND News.
The Illinois Supreme Court is considering this case.
A ruling is expected in the next several months.